A 6-year battle over breathalyzers used on suspected drunk drivers is finally decided by the Minnesota Supreme Court. Lawyers argued these tests were not reliable, that the technology of the Intoxilyzer 5000EN was flawed. But today, the justices, by a 4-3 margin, said while there may be some errors in the code, overall accuracy is not affected. That means more than 4,000 pending DWI cases will now move forward once again. And that has a lot of people asking questions about what this decision means. So we're talking to criminal defense attorney Chuck Ramsay, who is an expert on drunk driving law and these devices that police use. Chuck, let me start by saying, what does this mean for someone who got a DWI, say, 5 years ago and was challenging the results?
Randy, the Supreme Court is sending all of these cases back to the trial court now, where they will be litigated individually.
This was a split decision. 4 of the 7 justices agreed that even if there were errors in the Intoxilyzer, it was minimal. Are you surprised by the decision or any parts of that decision?
I'm very surprised, Randy. In fact, 3 justices said that these are critical flaws in the software, and a jury should be told of these flaws. Unfortunately, the majority says, no, we're going to keep that information from a jury. And unfortunately, then juries won't be told the truth about the problems with the software.
I want to ask you about the margin of error with that technology, the perceived margin of error. If someone blows, for example, a 0.15, which is almost double the legal limit, is it even possible for the breathalyzer to be off by that much to actually make a difference? Would anybody ever challenge something that wide?
Well, the question really is, first of all, is it admissible? Should this test even come in? And the Supreme Court said, yes, it should come in. Once the test result is admitted into evidence, the next question is, well, how much weight should we give this test result? And we have found, not that there's a theoretical margin of error, but there is actual error in this machine, and depending on the level, it's about 10%. So I would say, to answer your question specifically, at the level of 0.15, it probably wouldn't make that much of a difference, but certainly when we get close to around the 0.08 mark, it makes a significant difference in the final test result.
A lot of people watching this, Chuck, are going to go, well, here's a defense attorney. He defends, suspected drunk drivers. His job is to muddy the waters enough to create doubt in a jury's mind. How much of that, if any, is going on with and you've been talking about the inaccuracy of these for quite some time now, but from your perspective, how much of this is muddying the waters for a jury?
Well, it's true. I have a duty, an ethical obligation to be a zealous advocate for my clients. We're talking about someone's livelihood here, their family, someone's ability to earn a living. And so if we don't have good scientific equipment to conduct these tests, then it can wreck lives. And so it's more than just a defense attorney muddying the waters here.
Question that many ask, and I want to end with this one. Viewers will say, oh gosh, I got pulled over, I got a DWI. What should they do in that situation? Should they take the test? Should they concede to a blood test? I mean, what's your advice?
Well, under the law, it's a crime to refuse a breath test. So a person should not refuse, but instead they should beg the officer to give them a blood test, not one of these breath tests that are not scientifically valid, reliable, or accurate.
All right, Chuck Ramsay, we appreciate your time tonight. Thank you.
You're welcome, Randy.